It's time for another episode of the real crimes of Kurri Kurri. Yes, it's just one of the small local courts in New South Wales that offers a glimpse into the petty crimes happening in a typical Australian town. Kurri Kurri local court sat this week on Tuesday, the 26th of November 2024. And on this day, I'm going to say there was a common assault theme. Sure, there's the usual disqualified drivers, but today there was some assault cases where there was no complainant. Interesting. Also, even though technically we're in spring, it's hotter than the surface of the sun outside the courtroom. So the ceiling fans are on full ball, meaning it's cool inside the courtroom, however, it's hard to hear. So on days like this, you'll be allowed to lift your voice when addressing the magistrate. Technically, it's not yelling at the magistrate, but it is as close as you can get. It even gets noisier in the courtroom when the fire truck from the station next door departs. And a few people curtsied entering and exiting the courtroom rather than bowing, which is nice. And of course, there's always a case listed that isn't a Kurri matter. Today it was from Charlestown, so it was transferred into Newcastle local court. It was an interesting day here at Kurri. Anyways, two of the cases we were following from last time were finalised. Remember the guy who was charged with driving on a traffic island with a missing seatbelt? On this day he returned and pled guilty. So how much was he fined for driving over this painted traffic island attempting a U-turn? $410, and a conviction was recorded. The woman charged with the fray returned and pled guilty. She also pled guilty to stalk and intimidate and failing to disclose driver-passenger identity. Remember from last time, there's a co-accused also charged with a fray from this incident in June 2024. That person's pled not guilty and a hearing is set for over at Cessnock. I think there might be 6 sides to this story. So I'm going to hold off talking about her sentence until the co-accused is dealt with, and I'll talk about them all together. Before I discuss the common assault cases, here's a summary of the rest of the cases sentenced on this day. There's the tradie who's running a business which employs a bunch of tradies who drove one of the work vehicles to one of their jobs. Police stop him and breathalyse him, which is negative. However, the vehicle isn't fitted with an interlock, which is a condition of his licence because of a previous mid-range drink driving charge. He was convicted and fined $550. The magistrate explained that general deterrence was fundamental in this sentencing. But for general deterrence to have any sort of chance, we outside the courtroom need to hear about the case to be deterred. Next case was a guy who had lost touch with community corrections. It was adjourned to allow the guy to attempt to get back in touch. So when it returns, if he isn't back on track with community corrections, the court will re-sentence. I think the court will likely choose another way to keep him in touch with corrective services. Spoiler alert, it's a jail cell where you will be very available to keep in touch with corrections. Then there's the guy who parked his car on the gravel shoulder near his house. It's not blocking anyone, but the legal problem is it's unregistered. The offence is called standing an unregistered vehicle on a road. He has been watching YouTube in an attempt to fix the car and get it back on the road. The magistrate asked him a couple of questions where this guy admits the car is still parked there now, meaning technically he could be charged for this offence again. He gets a 3-month good behaviour bond. Now onto the common assault cases. They're both unrelated. First one is from November 2024. The defendant is a 19-year-old female who's pled guilty to common assault. Story goes, the defendant and the male victim are partners and are living together. They are inside their home where they argue and the defendant slaps the male. It's then understood she keeps coming for him, so he squirts her with fly spray and the police become involved. The male victim doesn't make a statement to police. Instead, the evidence the police depend on to charge the defendant is her own admissions. She admits to police she slapped him. By the way, we don't hear what form of evidence because she pled guilty, so they don't go through the evidence, rather the case just goes to sentencing. My guess is it's very likely this evidence was captured on police body-worn footage when the police were questioning her, probably at the scene. That's just a guess. She's given a conditional release order for 9 months with 2 conditions. First condition is that she must not offend, and the second is that she has to return to court if required. No conviction is recorded. The second common assault charge is also without evidence from the victim. The victim is her partner. The story goes, the defendant and the victim are staying at a relative's house when they are kicked out in the middle of the night and therefore find themselves homeless. The incident happens in a park early in the morning. The defendant and the victim are possibly arguing. It is very hard to hear because of the ceiling fans that are at top speed and are very noisy. A nearby witness allegedly saw the defendant throw rocks at the victim and the police become involved. By the way, the rocks don't hit the victim. Again, the defendant makes admissions to police, which they use as evidence to charge her. She's also given a conditional release order with the same conditions as before, not to offend and to come back to court if asked. No conviction is recorded. So sometimes evidence from the defendant is used to charge the defendant. This isn't unique to Kurri. This can happen anywhere in New South Wales. So I'll be back when Kurri Court sits again in December for the last court day of 2024.